Lady and my Lords, the motion that I make before this court is for the appeal to be allowed and for the parties to be permitted to put in a written submission as to what should happen next. It's anticipated that if the appellant is successful, we'll be asking the matter to be remitted to the Court of Session to proceed as accords. And obviously any question of costs and expenses can be dealt with at that stage. The facts are, as outlined in the Statement of Facts and Issues and briefly outlined in the written case, and I intend to proceed in the assumption that the Court has taken the opportunity of reading both of these, and I don't wish to repeat them in any detail. But the critical issue in this case, in my submission, is whether the director of a company owes a duty to an employee to have in place employer's liability insurance. And as will be seen from the Statement of Facts and Issues, in this case, the pursuer was injured at work using a woodworking machine. His employer had failed to obtain insurance against that risk and is now in liquidation. And what we say is that the structure of the 1969 Act is such that the duty was created and the defender has a personal liability to the pursuer, and we invite the court to so find. As far as the history of the case is concerned and the authorities that are important, of course, in 1995, the Court of Appeal in England, in the case of Richardson, concluded that there was no such duty. And we recognise, of course, the considerable respect that that decision has to be afforded. But we maintain that the decision was wrong. I'm sure that the Court has noted that there was a dissenting judgment by Sir John McGaw. And
we're for all, aren't we?
I'm sorry, my lady?
Aren't we for all?
My lady, I'm having difficulty.
Are we not for all?
Well,
the first instance judge and one judge in the Court of Appeal in both cases.
It is indeed. The way it happened in England was that the master originally found, I think, in favour of the defendant on appeal to a judge in the High Court. That appeal was successful and then reversed by the Court of Appeal. And a not dissimilar series of events took place in this case, with Lord Glennie at first instance disagreeing with the majority in Richardson, being overturned in the division, but the dissenting opinion from Lord Drummond-Young. And I think it must be obvious, at least to everyone, and I acknowledge in the written case that there are, of course, arguments both ways. I can see that, but as will be anticipated, I say the arguments in favour of the pursuer, and with the dissenting judges in the Court of Appeal in the Inner House, I submit were correct. I don't wish to overemphasise a point. We haven't lodged any paperwork in respect to this, but my learned junior, Mr. Murray, has been deviling to try and find if there are any statistics about the importance of this in the real world. And he came across a paper published by the Health and Safety Executive in 2003. I recognise the limits of the sampling process, but the HSE wrote to a number of employers of various sizes of businesses and invited them to basically confess whether they had insurance of employers' liability. And they received a surprising number of results which said that employers didn't have insurance, which by their estimate affected about 112,000 employees who are, I was going to say labouring, I suppose strictly they are labouring without their employer having in place insurance. Other studies, particularly the Federation of Small Businesses, came up with a much higher figure, about 8 times that. But I know that there are difficulties with surveys of that kind. But nonetheless, the problem is one which can, of course, be material. It will only affect those, of course, who have an accident with, in this particular case, employed by a limited company, which is in liquidation, which is then uninsured. So the sampling depletes at every stage. But nonetheless, if there is a single employee who is working away, thinking his employer, a limited company, is insured, who has a catastrophic accident worth many millions of pounds, the point is, in my submission, extremely important. Now, the structure of the submissions I intend to make are as follows. I intend to go to one authority.
There's no process equivalent to the position in relation to motor cars of checking that employers have any sort of insurance company.
Well, the regulations, my lord, they provide, which I'll come on to, made under the Act, they allow for the inspectors who are appointed they are given the power to demand to see not just the certificate, but the policy of insurance.
Yes, well, I mean, everybody knows that you have to have a notice up to the effect that there is insurance, but
Yes.
Unless the inspectors exercise their powers, there's no automaticity about the check. You don't have to submit it or make an internet entry every year when you take out your insurance.
No, I see my Lord's point. No, as far as I know, there is not such a system in place. But the regulatory system is the obligation to display, which is under the Act
Right.
and under the regulations,
Right.
plus the power of inspectors to demand to see the certificate and the insurance policy. Of course, someone may put a certificate up saying that they were insured, but it turns out that, in fact, they're not insured, as the position, no doubt, could have happened in this case, that there was an exclusion. And the exclusion, of course, in this case was, rather surprisingly, the use of woodworking machinery.
Yes.
So there may have been, in fact, I'm sure there was a policy of insurance technically in place, but it didn't cover the very risk that manifested in this case. But I'll come back to the regulations in a few moments. But what I intend to do is to go to one case, which I say is case in tab 8, Black against the Fife Coal Company, MS 219, which gives an outline of what the rule is, just to give a context to my submissions. I then intend to go to the legislation and look at it in a little detail. I then look in a bit more detail at the authorities, including the Richardson case, and then consider some points that the respondents make. And finally, and perhaps illogically to deal with it last, to look at very briefly, I hope, the reasoning of the Inner House in this matter, as hopefully by the time I get to that point, all of the points that they make will have been discussed in some detail. So perhaps before looking at the authority of Black, I should say this, that the respondents take issue with the characterisation of the obligation that we're pleading for. What they say is, well, is this common law? Is it statutory? What is it? And my response to that is it doesn't really matter very much what it's called. We say that there was a duty, and that's what we're inviting the court to find. But the court may find it interesting that Professor Glanville-Williams points out in an article that is lodged here, tab 26. It's about the middle of the page. I don't intend to go to it, but it's MS 763. He describes it as statutory negligence, which is a useful blending of the two terms. But the characterisation of the obligation in my submission is not important.
Well, Lord Glennie's decision that there was no common law duty of care hasn't been appealed against.
I accept that, my Lord.
Yeah. So the argument has to be that the statute directly imposes a civil liability.
Yes, that is the argument. As I say, whether it can be properly described as a statutory breach or whatever, my submission is not, in fact, that important. The question that we're here to have determined is the question of whether there was a duty in some respect on the directors to make sure the insurance was in place. Now,
Yes, I mean, obviously there was a duty in criminal law terms, in some sort of sense, otherwise they wouldn't be vulnerable to punishment. It may matter what sort of duty one's talking about. We're talking about a statutory tort here, aren't we? Where is Professor Granville-Williams' statement
it should
in?
be, if my notes are correct in this, it
Which
should
page?
be 763.
763, thank you very much.
Tab 26, it's
Yes.
about the middle of the page. It's the last sentence before the new paragraph begins. He says, in such circumstances, and my lords and my lady can read it for themselves, it's better to speak of statutory negligence than of absolute liability, the fault in which the standard of conduct has been fixed by the legislature instead of by a judge. That's the kind of characterisation that he places upon it. Now, I promise
He's talking about the classic situation, occupiers' liability, where it was encapsulated in the statute, but effectively it's the old, for most purposes, I think, the old negligence duty. Unfortunately, in occupiers' law, there wasn't always a negligence duty. It was a very quirky branch of the law.
Yes, the context in which he's discussing it covers situations, in fact, such as the Black against the Fife Coal Company case I'm about to come to, which, in fact, perhaps I can just take the court to that just now. It's to be found in tab 8. It begins at MS 219, and the passage that I would wish to refer to is MS 235. And the facts of that case were that there was a statutory obligation basically to remove all mine workers from a mine if there was the presence of noxious gas. The deceased was not removed when there was known to be noxious gas. He was killed and his widow sued. And the question was whether the mine workings legislation that required the removal of the workmen imposed a civil liability. And it was held that it did because of the structure of the legislation. And the passage, I don't intend to read out much of any of the authorities that I refer to, but to place this in context, if I could read just a few lines. MS 235, reading from the last paragraph on the page, just about more than halfway down. If the duty be established, I do not think, and this is Lord Kinnear, I do not think there is any serious question as to the civil liability. There is no reasonable ground for maintaining that a proceeding by way of penalty is the only remedy allowed by the statute. It refers to some authorities on that matter. Reading on, we are to consider the scope and purpose of the statute, and in particular for whose benefit it is intended. Now, the object of the present statute is plain. It was intended to compel mine owners to make due provision for the safety of the men working their mines, and the persons for whose benefit all these rules are to be enforced are the persons exposed to danger. But when a duty of this kind is imposed for the benefit of particular persons, there arises at common law a correlative right in those persons who may be injured by its contravention. And he finds it quite impossible then to hold that the penalty detracts from that particular matter. So what I take from that, and I'll submit that nothing has really changed from that in the context of this particular case, that what we look at primarily is to see for whose benefit is the legislation intended. And as will be anticipated, I say that the 1969 Act, when taken in conjunction, I will submit, taken in conjunction with the 1930 Third Parties' Rights Against Insurers Act, it's plainly designed to provide a benefit from an employee and probably only an injured employee who then, as it were, is crystallised as being the beneficiary.
It's interesting, is it not, that he describes it as a common law right, approaching it, I think, on this basis, that it is a judge-created right, but based on a statutory obligation.
Yes.
And the courts have then taken on themselves to say, in the cases of certain types of statutory obligation, we will recognise a duty enforceable in the civil court.
That's correct, and that's why I make reference to the Professor Williams' way of approaching it. But the terminology in my submission is not really important because the question is an obvious one. But what I will submit is that the particular way that it's put in the Black or Butler case is the correct way of approaching it.
But that way of putting it isn't the way that it's put in more modern authorities, where the whole emphasis is on the language of the statute and what objectively can be taken to be the intention expressed by that statutory language.
Yes, that is right. I fully accept that that's what one is doing. It is simply the way it's put by His Lordship, by Lord Kinnear, in the case, and my submission is the correct way of approaching it. But
it's easy to see how one can do the exercise identified by Lord Kinnear at 235. We are to consider the scope and purpose of a statute, and in particular for whose benefit is intended. And that is a straightforward exercise of construction.
Yes.
There is, as commentators have pointed out, a certain degree of artificiality when Parliament is then silent on the question of civil remedy about purporting to interpret an intention that there should or should not be civil liability.
Yes. Well, I can't remember where I read it, but in preparing for this, one of the unhelpful comments I read was to derive the intention of Parliament from the statute. One reads the statute, then decides what the intention of Parliament was, which is, of course, not only circular but distinctly unhelpful. But the question I see that's important here, there's a theme running through all of the authorities, right through X and Bedfordshire and so on, and Lonro, is the point that one asks the question, for whose benefit? Who is it that this is designed to benefit? And indeed, the Richardson case, Court of Appeal decision, is one which they concentrate on, or Lord Justice Stuart Smith. He concentrates on the question of benefit and tries to derive where the benefit lies.
But it can't be as simple as that. I mean, one could point to road traffic law, for example. It's full of offences designed to protect pedestrians, it may be, or to protect other motorists. And nobody imagines that the intention to protect a particular category of person in itself infers a civil liability.
Yes, my Lord, I accept that. And I think the way Lord Brodie approached it in this case was he said, under reference to the Aaron Parkhurst case, he said that something more is required. And the something more that I say applies here is that we have the combination of the legislation, the 1930 Act, together with the 1969 Act. It creates a package. And in my submission, that's important. And as we'll hopefully see in a few moments, when one looks at the Monk and Warby case, which is the road traffic case, which I say is pretty well indistinguishable, the combination of the two factors was one which led the court to a conclusion that, they didn't put it this way, but there was something more. You had the 1930 Act entitling recovery directly against the insurer, together with the obligation of insurance. So I accept my Lord Reid's point that it's not as simple. I was considering this morning the question of road traffic legislation, for example, the obligation to drive at 30 miles an hour. Could someone say that if their child was killed by a car travelling at 30 miles an hour, that there was a duty to make it 20 miles an hour? Well, something more is required than just simply that obligation or the statement that one has to drive at 30 miles an hour. But I say the importance here is the combination of the two pieces of legislation.
Sorry, I didn't hear what the two pieces of legislation were what?
The Third Parties Rights Against Insurers Act 1930 combined with the 1969 Act. And as my Lord will no doubt be aware of the 1930 Act, what it does, it gives a right to the injured party, the injured person, to take proceedings directly, essentially to take them. The money obtained from the insurer doesn't form part of the state.
Yes, I mean, I know about the Third Parties Act. I'm just slightly surprised that you use that to construe the 1969 Act.
Well, I say that's legitimate, and I'll come on to Monk and Warby, where the court, in that case, considered that the combination of the two pieces of legislation did create a package. Before, perhaps if I just take my Lord to that point just now, if the court turns to page 524 in the bundle, this is in tab 16, Monk and Warby, which I'll come back to in a little more detail, Lord Justice Greer, and it's down towards the bottom of the page. The facts in this case were that the plaintiff was injured in an accident, and the car that was involved in that accident wasn't driven by the defendant. The defendant was essentially the owner of the vehicle, who had the primary obligation to make sure it was insured for its use. And the driver of the vehicle was not insured to drive it, so the action was against the owner or the keeper of the vehicle, saying that he had an obligation to make sure it was insured. But his lordship says, the last paragraph on page 524, the Road Traffic Act 1930, under which the question arises, was passed in these circumstances. It had become apparent that people who were injured by the negligent driving of motor cars were in a parlous situation if the negligent person was unable to pay damages. Accordingly, two statutes were passed, one for the purpose of enabling persons who were thus injured to recover, in the case of the bankruptcy of an insured defendant, the money which would be payable to him by the insurance company, Parliament enacted that in such circumstances the insurance money should go not to the general creditors of the bankrupt defendant, but to the injured person. In other words, the injured person, although not a party to that to the insurance, could make the insurance company liable. And it goes on to essentially, one can see the reliance on the if I put it this way, the package, that the two acts come together. I'll come back to the Third Party Rights Against Insurers Act in due course, but perhaps if I can take the court now to the 1969 Act, which is to be found in page 137 in the MS numbers. And of course, the structure of the Act is important. It's a short Act, and Section 1 is the one that contains the obligation on the employer. And just reading the detail of it, except as otherwise provided by this Act, every employer carrying on business, and incidentally, the exceptions there are for things like health boards and local authorities. Every employer carrying on any business in Great Britain shall insure and maintain insurance under one or more approved policies with an authorised insurer or insurers against liability, etc., sustained by his employees and arising out of in the course of his employment. And there are various definitions in Section 1, Section 3 as to approved policy and authorised insurers and so on and so forth. Section 2 has the definition of employees to be covered. There are some exceptions under sub 2, which is those basically in a close relationship. The defender makes something of this and says that's anomalous. I'm not sure I entirely understand whether this could be said to be a point that's neutral, a point against me, a point for me, but one might anticipate that if your only employee was your brother, you might think it a prudent thing to do to take out insurance in any event, rather than have the compulsion if it was someone who was essentially a stranger. But I'm not sure that much can be taken from that. Section 4 of the Act on page 141 relates to certificates of insurance, and sub 2, A, just reading into it, regulations may be provided such that comply with any regulations requiring him to display copies of the certificate of insurance for the information of employees. That I say is important because what it does is it allows an employee to know with some degree of certainty that his employer has complied with the obligations. So the requirement that an employee can see it, in my submission, is a signpost which indicates that the beneficiary is the employee. And Section 5 is the important section that this Court's been asked to interpret as standalone. Penalty for failure to insure an employer when any day is not insured in accordance with the Act. This Act, when required to do so, shall be guilty of an offence and should be liable, etc., to a fine. And where an offence under this section committed by a corporation has been committed with the consent or connivance of, or facilitated by any neglect on the part of any director, manager, secretary, or other officer of the corporation, he, as well as the corporation, shall be deemed guilty of that offence and liable, etc. Now, that's the section that the Court's been asked to look at. But before looking at the regulations, which are...
Sorry, I mean, you depend on 5 to bring in.
Yes. Well,
and how do you read it? I mean, it's pretty specific in its wording, isn't it? It talks about being deemed, slightly odd concept of being deemed to be guilty of the offence. You have to say they're deemed to be civilly liable as well, do you?
Yes, I say that. Right, because of the terms of the section and in the context of the Act. And I come back to the point I made at the outset, which is that what I say and what I submit is that the intended beneficiary of the Act is the employee. I say that...
Yes, I mean, that's clear, but I mean, the liability of the not just the company, but of the directors is what you've got to fix, and you depend on 5 to get you home, and that involves a rewriting of the section, doesn't it? In my submission, it's not really a rewriting of the section, it's what the section says.
it's deemed to be, I accept, of course, that's what's said, but there's a deemed wrong, if I put it in the most neutral terms that I can for the moment. And I say that when one looks at the context of the rest of the Act, what that results in is a civil liability, and it's not restricted to the penalty as the way it's put in the black case that I referred to earlier. Now, the regulations which were made under the Act are in tab 2, and what I will submit is that there's a follow-through in the apparent beneficiary being the employee, and we can see that what these regulations essentially provide is two things. First of all, that the insurance policy is what one might consider to be a gold standard, a gold-plated insurance policy to benefit the employee. And the second thing is a method of scrutiny that the obligation is being complied with. And we can see from Regulation 2 on page 147 that there's a prohibition of certain certain conditions and policies of insurance. It's got to be a compliant policy of insurance. And, for example, in Regulation 2, sub 2, we can see that a prohibited policy includes one which requires a relevant employee to pay or the insured employer to pay the first amount of any claim or aggregate of claims. So if it's really a condition precedent that there is payment of an excess, what we would understand is an excess, it's not a valid policy. Just for completeness, sub 1 of that rule indicates that certainly standard exclusion clauses or clauses which would allow the insurer to avoid liability would not be valid. For example, that failure to report on time, that kind of thing, cannot be in a policy of this type to be compliant.
Just looking at the regulations, the employer is under an obligation to display at the workplace.
Yes.
But the form of certificate which he's required to display, we get at page 153, don't we?
Yes.
So even if the employee were interested in insurance law and the fine print, he wouldn't actually be able to see what the terms were.
Right.
He would reasonably believe that he was covered, or rather that his employer was covered, by dint of that certificate.
Correct.
If one had the problem which has arisen in this case, the only way that would have been detectable would have been by production of the policy.
Indeed so.
And that is something which the inspector is entitled to see.
Yeah.
But the employee isn't.
Correct. That is right.
Regulation 7 deals with inspection of policies.
Yes. Regulation 6 is the entitlement of the inspector to demand to see the certificate of insurance. 7 entitles the inspector to see the policy.
Correct.
Which may, if that had been done in this case, might have disclosed the problem which has arisen. The point I make from this, and Millard may be suggesting that it doesn't go very far from the employee's point of view, but what I say is it goes much further than any other system of insurance that is in place. And it's clearly designed to confer some comfort, maybe misplaced.
That A, this is intended for the benefit of the employee, and B, the employee has the security of seeing that there is a certificate of insurance in place.
That is right.
What he wouldn't be able to know is what the terms of it were.
Of course, and there may be things that even an inspector wouldn't be able to work out. For example, a material non-disclosure, if there was such a thing, that an inspector might see the policy but not know what's happened before it. However, there is what I say is there is a scheme here that is plainly designed to regulate and to enforce to some extent, but the reason for that, I submit, is that it's because it's benefiting a third party. Now, of course, generally speaking, insurance is not something that is compelled.
Generally speaking, insurance
It's not something that is subject to compulsion.
No.
because what we have is a few instances where there is compulsory insurance. Road traffic is the obvious example. This situation, employer's liability. Our researchers have trawled up one other example, which is in the Tenement Scotland Act, which requires where one has common parts of a building, there's an obligation to take out buildings insurance. That, interestingly, the Act says it can be enforced by one of the co-proprietors. Now, again, that gives an example that compulsory insurance, and I say that compulsory insurance, where it is compulsory, is there to benefit the injured party at the end of the day.
Did you say tenements?
The Tenement Scotland Act, yes, my lord. Try and give my lord the, yes, 2004 Act as amended. Tenement Scotland Act. I think it's section 10. So what we have is a situation here that we know that there are some examples of compulsory insurance. The only other examples I could think of are not so much statutory, but certain professionals, barristers,
well,
advocates,
compulsorily insured.
and doctors required to carry insurance by professional obligation. One might argue, is that to benefit me to have to carry insurance? Of course it benefits me if I'm sued, but is the primary beneficiary going to be the client? And what I say is the compulsory nature of it and the regulatory system that's in place is to benefit the employee.
Can I ask another question? Because there's a whole new world beyond this case which we can't investigate, but which is of some interest. The insurance certificate, I assume there was one here, and perhaps there wasn't. But if there was, whoever were the insurers certified that the policy which this certificate relates satisfies the requirements of the relevant law applicable in Great Britain, i.e., on the face of it, they certified that it was a policy which covered the business of joinery, and it would be very surprising if the business of joinery didn't include the use of electrically driven saws. So on the face of it, there may well be a claim against the insurers, whatever the policy exception was, although perhaps your client would have to show that he relied on this or knew about it. But leave that aside. There is also the brokers. There were some brokers who placed this policy, and how it comes about that a joinery firm doesn't have a cover for joinery work by electric saws, one hasn't a clue. But on the face of it, there is a considerable cause for investigation and some obvious cause for complaint.
There is perhaps in response to my Lord's first comments, if we're unsuccessful, we might be seizing on these observations against the insurance company.
Well, I think they're fairly obvious. I'm not inviting litigation, which isn't, I understand, already hinted at in the papers. But, I mean, obviously there will be possible problems because, let us suppose, the cause of action may well be in the hands of the company, which is liquidation, so that the recovery, if there was a recovery, would go into the liquidation pot.
Yes.
And one doesn't know how bust this company is, but it may be that that would diminish the amount available for you.
Yes. The position is that we are aware that...
I just want to understand the whole perspective of this case.
Well, Lord Drummond-Young records that I advised him, and I'm sure this will be confirmed, that an action has in fact been raised against, we say this in a written case, against the broker. It's been raised in the name of the director against the broker, which may create some difficulties, I can see that, but and again, I'm not giving anything away. There's active discussion between the parties here about assignation of any rights.
Yes. Because
unfortunately the defender has become personally insolvent in this matter quite recently. So there are a number of things going on in the background.
Then it's rather a bad idea to claim in his name. You ought to be making sure you claim in the company's name.
Well, we're looking at every potential target, but the point about suing the broker is an important one, because one of the points that's made by the judges is that the judges against me is there's a very onerous thing on a director who maybe by inadvertence overlooks the taking out of insurance or takes out a policy which isn't suitable or doesn't cover. But my response to that is quite simple, that for no cost to him, a director can go to a broker, and the broker is bound by various rules and regulations under the Financial Conduct Authority to make sure that the policy he recommends to the client...
But they did go to a broker here, didn't they? They did go to a broker.
They did go to a broker.
Yes, so that, I mean, Mr. Gordon would say, presumably, if I am liable, well, he may have difficulty claiming contribution, I suppose, because it's a statutory tort.
It is. Of course, that only will arise if we're successful here.
Yes.
If we're unsuccessful, then there's no complaint that we can be validly making against the director in that respect. The matter is complicated, but the way I think we ended up discussing this is talking about compulsory insurance. And if I can make the obvious point that there are many insurance products out there in the market, holiday insurance, contents insurance, even public liability insurance when one owns a property. And it's seen in my submission, it's quite obvious that prudence is the driving factor for most people to take out insurance. It's sensible to do so. Where you have compulsion, in my submission that gives a different character. It's seen as a matter of policy by Parliament that it's a proper thing under some circumstances that someone who may not be motivated by that prudent conduct is compelled to do so. And I say that the compulsion here is that it's right then when someone goes to the workplace and they see a certificate hanging in the wall, that, or even if they don't see a certificate, they've got a right to expect that if they're injured in the course of their work, that there will be someone there to pick up the tab for their injury. And I say that's the compulsive or compulsory nature of the legislation is something that's important. The final point I wanted to deal with
Well, in the case of a larger employer, one would imagine that the employees would have their own organisation within the plant, whether it's unionised or simply a workers' representation council. And checking on the certificate, one would imagine, would be a fairly routine part of the responsibility of that organisation. One wouldn't expect every employee every morning on coming on duty to go and look at the notice board to check the certificates there.
One would be surprised if an employee had the inclination to do so, but nonetheless the way the legislation is worded is to allow that facility if someone wishes to avail themselves of it. The final point I wanted to look at dealing with legislation is to show by contrast something in the Health and Safety at Work Act. And this can be found in tab 3 of the bundle at page 167. Section 37 contains a provision about offences by bodies corporate, and without reading it out, it essentially comes to pretty well the same thing as in terms of Section 5 of the 69 Act. But of course, what we see in the next page in the bundle 168, Section 47, is the provision that nothing in this part shall result in civil liability. So there is a method, a clear method, a tried and tested method, that if civil liability is to be excluded, it is specifically excluded. And the Health and Safety at Work Act gives an example of that. And of course, there is no such exclusion in the 69 Act. Now, my lady and my lords, what I don't wish to do, turning to the authorities, is to trawl through a chronological analysis, because there's a good deal of law about the interpretation of the various statutory provisions. And summarised, I say, effectively, and not departed from in subsequent cases, in the Lonhro and Shell case, which is to be found at tab 16, in particular Lord Diplock. This is the passage is at page 514, MS numbers. Lord Diplock in Lonhro. And the part that I intend to read is just between letters B and C on 514 towards the top of the page. after the reference to Doe de Murray and Bridges case, where he spoke of the general rule that where an act creates an obligation and enforces the performance in a specific manner, that performance cannot be enforced in any other manner, a statement that has frequently been cited with approval ever since, including on several occasions in speeches in this House. Where the only manner of enforcing performance for which the Act provides is prosecution for the criminal offence of failure to perform the statutory obligation or for contravening the statutory prohibition which the Act creates, there are two classes of exception to the rule, and I rely on the first exception. The first is where upon the true construction of the Act it's apparent that the obligation or prohibition was imposed for the benefit or protection of a particular class of individuals, as in the case of the Factories Act and similar legislation, and the Black and Fife case is referred to. The second exception we can see above G is where the statute creates a public right, i.e. to all of Her Majesty's subjects, and of course I'm not suggesting that here. So what I say is that that definition is the one that this court should be applying, and of course I've readily acknowledged that it's been subject to discussion subsequently. For example, in X and Bedfordshire, tab 22, at MS 694 is the passage I intend to refer to, Lord Brown Wilkinson. 694, the passage, we can see that Cutler and Wandsworth and Lonhro and Shell were cited with approval, and it's at letter G. What his lordship said is, however, the mere existence of some other statutory remedy is not necessarily decisive. It's still possible to show that in the true construction of the statute, the protected class was intended by Parliament to have a private remedy, and so on. So again, there's no departure from the principle, and nothing certainly to suggest that what was said in Lonhro is not correct.
Well, the bit which is relied on against you is at letter D.
Yes, I fully acknowledge that, my lord, but the whole paragraph has to be read, I say, together.
And you say that the citation of Lonhro is a reference back to what you've just been taking to us, 185, with no suggestion that Lord Diplock was unduly favourable towards beneficiaries in his analysis.
I say that well, what one has to be careful about is to lift any single sentence from any particular case and say, well, that compromises the Lonhro rule, or it compromises the rule developed in other cases. If that was the case, what I would respectfully suggest would appear in the decision is, to the extent that Lonhro says this, it goes too far, or it doesn't go far enough, or it has to be qualified. And what we don't see is any compromise of the passage I read from Lonhro.
And the opening section of that paragraph, the principles are well established, doesn't suggest that he's intending to depart from them.
Correct.
And you say that when you look at Cutler, Wandsworth, Grosvenor, Wimborne, Lonhro and Shell, the message is pretty clear.
They all fit together in a continuum.
The difficulty is that actually, I mean, he might as well not have written this paragraph, if that's right. It does depart from the Diplock approach because it puts the matter the other way around entirely. Diplock, Lord Diplock, I should say, starts off with the proposition that where a statute creates an obligation and enforces the performance in a specified manner, that performance cannot be enforced in any other manner. He then qualifies it by reference to a specific exception. If you look at Lord Brown Wilkinson, he puts it quite the other way around. The exception becomes the general rule, and
Is that right?
As I see it,
You would say that it's rather odd if you're intending to depart from established principle to begin by saying that you're not.
That's my submission, but perhaps I can also say this in response to Lord Manston, that I say whichever way around we put it, we still come to the same result because of the structure of the legislation. But I do say that there's a very good deal of authority that lays down the principle in the way that I'm advancing, indeed, high authority that lays down the principle that I'm advancing.
One's got to be very careful, even with judgments of the highest authority. You don't take a sentence and treat it as if a language was statutory.
Precisely. I of course, fully acknowledge that. And one can be over-analytical in any judgment and say, and I'll come back to the question of Lord Rogers' comments in Morrison Sports case that my learned friend relies upon, suggesting that there's been a compromise of the position in earlier cases. In my submission, that's taken.
I think, the difficulty I have is that Lord Diplock, if you took him, would give you an extremely simple two-part test. The whole purpose of what Lord Brown Wilkinson is saying is that there is no simple answer here. There are a number of indicators, even where a statutory duty is imposed for the protection of a limited class of the public. You have to have something further. That's the critical point
Yes.
at D. And Parliament must have intended, as a matter of true construction, to confer on members of the class a private right of action for breach of the duty. And then he goes into all the factors which are relevant there. They might have so intended if there's no other remedy. If there is another remedy, then that's a pointer against their so intending. However, the mere existence of another remedy is not necessarily decisive. It still may be that on a true construction of the statute, the protected class was intended to have a private remedy. You get back to Groves and Lord Wimborne. So it's a very sophisticated analysis as opposed to a rather simplistic two-part analysis. That's why, at the moment, I see this paragraph as different. Now, I agree we can't read anything in a common law judgment as if it were a statute, but this is, I think, guidance which Lord Roger followed in the Morrison case.
Yes.
First, it does seem to me that Lord Brown Wilkinson would have been rather surprised if he'd been told that you've just reversed what Lord Diplock was saying.
Well, that, of course, is my primary submission, but as my Lord Mance has pointed out, there's nothing actually very easy about this, which is, I suppose, why in many ways we're here with a dissenting judgment. The question of the test is not greatly in dispute, and I think Lord Brodie acknowledges that even the difference between the various cases is one more of emphasis rather than of practical solution, because we come back to the question, if we read the legislation and say this is clearly directed to benefit a class of individuals, yes, then that's
I think, you're on reasonably easy territory in indicating that statements to the contrary are perhaps a little surprising.
If that is so, but perhaps I can also say that, just make this final point about the authorities such as X and the Parkhurst case and so on. These are cases that have to, my submission, be seen to some extent in their context, and indeed Lonro have to be seen in their context. Essentially, public law cases where there no doubt would be a fear that every member of the public would come along and say, I have a claim here. What I'm dealing with here is something that arises from a private relationship between an employer and employee. And he says it's essentially a condition of my employment in many ways that you have insurance. So if there is a threshold to be crossed, I submit that it's a much easier threshold for me to get across in that kind of private relationship than it would be, for example, a prisoner who says that the regulations about prison, the running of a prison, gives me a right to a particular remedy because of the regulations. But and it may be a feature of this that the complexity that when one looks at the other authorities, in particular Monk and Warby, which I intend to come to in a moment, it's a case that, as far as I can see, has never been suggested to be wrong.
Well, I don't know about that. Glanville Williams was very critical of it.
Well, I was meaning in terms of any subsequent authority. And of course, there is a good reason. There's a good reason why Monk and Warby has not had to be relied upon, certainly since the introduction of the Motor Insurers Bureau, because someone who finds that the person who injured them is uninsured can go against the MIB for compensation. So perhaps I can't overemphasize that point, but Monk and Warby, if I can now turn to that, which is to be found in tab 16 at 520 in the bundle.
Monk and Warby was a case where there was on the face of the statute, though, a rather clear obligation on the owner of the motor car, wasn't there? I mean,
Yes.
when one lets one's car be used by other people, then one has to take a great deal of care to make sure that either you or they have relevant insurance cover.
Yes, well, I could say the same, that this case is about, I say a director has to take a good deal of care to make sure that the company he represents...
But the point I was making is that the statute actually put the duty straight on the car owner.
Yes, well, I accept that difference, and this may be where the question of deeming, the deeming provision in the 69 Act, it gives a different flavour to the circumstances, but what I say is it doesn't in fact amount to a difference in effect at the end of the day. And in the Court of Appeal in Richardson, there was some debate between the majority and the minority opinion as to whether the wording makes any particular difference to the outcome. Sir John's view was at the end of the day that it doesn't make any material difference. It comes to essentially the same thing. I accept, as my Lord has pointed out, that there is a difference because the obligation's on the motor car owner to do something. I accept that. But what I say is I can transpose that. It would be surprising if it was I find it difficult to see how...
Well, it was also quite an interesting obligation because it was one which was substitutable, rather amazingly. I doubt if it's still the law. At that stage, you could either insure or else you could yourself stand insurer by putting up what I suppose was a large sum of money in those days. I've forgotten what it was. You had to put up a bond or guarantee.
I may be wrong, but I think that's still theoretically possible, which is why some local authorities...
So, I mean, if you don't insure, well,
guarantee.
then the assumption is you've taken on the burden of insurer yourself.
Indeed, I can see that. But as far as Monk is concerned, perhaps I can take the court to a passage on page 526. 526. This is Lord Justice Greer. I already referred to a passage earlier, the conjunction of the Third Parties' Rights Against Insurers Act and the Road Traffic Act. What is said, and I'm looking at about just halfway down the page after a quotation from the Atkinson case, the result of the above construction may be stated as follows. Prima facie, a person who has been injured by the breach of a statute has a right to recover damages from the person committing it, unless it can be established by considering the whole of the Act that no such right was intended to be given. So far from that being shown in this case, the contrary is established. To prosecute for a penalty is no sufficient protection and is a poor consolation to the injured person, though it affords a reason why persons should not commit a breach of the statute. Going over the page, and it's important I submit that that's the conclusion they came to, but they go over, or His Lordship goes on to consider what was said by the then Lord Justice Atkin. Just about 5 lines down, he quotes, one question to be considered is, does the Act contain reference to a remedy for breach of it? Prima facie, if it does, that's the only remedy, but it's not conclusive. The intention is disclosed by its scope and wording must still be regarded, but it may still be that, though the statute creates the duty, provides a penalty, the duty is nevertheless owed to individuals. And after the reference to the cases, to my mind, in this respect, I differ from Sir Justice McCarty. The question is not to be solved by considering whether or not the person aggrieved can bring himself within some special class of the community, or whether he's some designated individual. The duty may be of such paramount importance it's owed to all the public. What therefore has to be considered here is taking the whole of this Act. Is there anything in it to show that an injured person is outside its scope? I'm satisfied there is not, and a person who suffers injury by reason of breach can maintain an action for that breach. And again, the theme keeps coming back to this question of protection. Now, what I submit is that the drive of what is said in Monk, despite Glanville Williams' criticisms of the idea, the drive of it is that one searches for the beneficiary, and if it's necessary to identify a class, I say the class of beneficiaries is employees. There's probably a subclass which is injured employees and a subclass of those who are injured where their employer is a corporation that's insolvent. How one looks at it is not particularly important, but it's not owed, as it were, to the general public. It's owed to employees. That is a requirement. And for reasons I've already submitted, I say that it's clear that the legislation, especially in combination with the 1930 Act, is one which adds something more, as Lord Brodie puts it, and creates the duty.
A particular feature here, but no doubt you'll come to, is the fact that the duty is primarily placed on the company, with the redeeming provision that an offence is committed by the director. And so far as the company is concerned, I mean, I appreciate you have an argument that the availability of interdict might be a viable remedy against the company, but the availability of a remedy in damages wouldn't add anything so far as the company is concerned. But it becomes much more important if it's available against a director.
It does, and of course, if the company was solvent, it wouldn't matter. We wouldn't need to go against the insurance company. We'd sue the company.
Well, solvent, bearing in mind the size of the claim.
Well, depending on the size, of course. There may be a very small company without much in the way of assets, but generally
Very big claim, yes.
Generally speaking, this would only trigger if one was wanting to invoke the provisions of the 1930 Act. But perhaps if I can just deal with that point. The obligation under Section 1 is on the company. Lord Drummond-Young analyses this in the following way. He says, well, there's nothing illogical about that because the company can only operate through the directors. That's all they can do. So they are, in fact, under an obligation.
Sorry, could you say that again?
Lord Drummond-Young's approach to this was, he says that the directors are essentially the operating mind of the company. And therefore, they are under, in practical terms, they are under the obligation to make sure the company complies with its obligation to obtain insurance.
Well, that maybe so as a matter of sort of common sense, but it's not so in law. It's a company which has an obligation.
Yeah.
And the basic principle of company law don't mean you can transfer that to the directors unless there's some specific provision.
Whilst I acknowledge that, my lord, the point that Lord Drummond-Young was making was that the directors are the ones who essentially put in motion the fulfilment of the obligation on the company, is the first approach. The second point that I think is important is this, that the company as the employer is the only one who can realistically take out the insurance. The director can't insure himself against claims by the individual. It would be a strange policy of insurance where the director is the named beneficiary for the employee, and of course, for the employee, and of course, what Section 1 does is the employer who is liable to take out the insurance. So the fact that there's a disconnect, a dislocation between the directors and the primary obligation to take out insurance is not surprising. In fact, it's perfectly logical in the circumstances.
Lord Drummond-Young's reasoning, namely that the directors, as part of their general responsibility for the management of the company, owed a duty to ensure that it implemented the obligation to insure, and therefore there was civil liability under Section 5, is what we've just been looking at. But if one just stops at the first half of that and doesn't make the second step, the first half of that is no doubt true, and particularly true, no doubt, in Mr. Campbell. Sorry, are we talking about? We're talking about Mr. Gordon, yes. Mr. Gordon's case. So, in fact, you have another course open to you, namely, in the name of the company, to hold Mr. Gordon personally liable.
Common law.
Well, he'll be liable for breach of his director's duties under the Companies Act, and once you've got control of this company, you'll be able to pursue both the brokers and Mr. Gordon if he's worth anything.
That may be so. Of course, what I say is that there may be difficulties in that particular approach.
Well, what greater difficulties than pursuing Mr. Gordon personally now?
Of course, I recognise there are difficulties in the approach that we're taking this action. the way it's being presented. But all I say is, if my lord is suggesting that, was that not the obvious route, and therefore we don't require...
I don't know about obviousness, but I'm suggesting it's a route.
I suppose it's a possibility,
Yeah.
but I say it doesn't detract from the question that's before the court in this case.
No, of course not. No. But if one's thinking about the proposition that led Lord Drummond Young to infer a duty or to conclude that there was a duty, it seems to me that the first step actually leads more naturally, or at least equally naturally, in a different direction, which is the one I thought through and which you agree, I think.
I couldn't quarrel with that proposition, but perhaps I should also say that the question of enforcement of the obligation is one that I've struggled with by the employee. If an employee discovers or thinks that his employer doesn't have insurance, and I'm not sure whether this is a point for me or against me, I struggle with the concept that he could somehow enforce that obligation by an application to the court, either by injunctive relief or by an application under the Court of Session Act to force the company to obtain insurance. I'm imagining from a Scottish perspective turning up and saying, I'm an employee, I don't think he's got insurance, I want you to order him to get insurance. I would imagine that a number of judges might say, well, you're not an injured employee for a start. I know that kind of puts the cart before the horse, but what's your interest in this in practical terms?
Well, I would have thought it would certainly not be a good answer, that. The judge would probably send the papers to the health inspector and to the public prosecutor and say this company is behaving completely inappropriately.
Well, one could see that, and certainly the employee could, I suppose, report the matter if he felt it wasn't being complied with.
I mean, his statement then, he first of all get in touch with the inspector and say, I've got a concern about this. Very simple matter for you to check, please do so. If the inspector says, no, I'm not prepared to do so, then that would be judicially reviewable. Yeah. Once you've got the information which you then require, if it's clear that the company is in breach of its obligation, he would apply for an interdict, query whether the courts would say, no duty is owed to you under the statute, so good day, or whether they would say, yes, no, this is intended for your protection, and we will grant the order.
The point I was trying to make, really, which I think Lord Tawson's put his finger on, is that it would be very curious if there was a civil liability and damages imposed on the director, unless there was also one imposed on the company. I mean, one might think, and this dual liability is a particular feature of this statute, which is quite an unusual feature.
Yes.
And so far as I can see, such a liability on the part of the company wouldn't add anything useful to the liability it's under in any event, if ex hypothesi it's committed a breach of statutory duty or a breach of common law, of its common law duty of care towards the injured employee. But thinking it through, I thought your counter argument was, well, that may well be so, but the liability might be enforceable before the event by way of interdict or injunction in England, and that would be of some practical value.
Yes, that is my position, my Lord. And the other way that we've been considering how this could be not so much enforced, but possibly enforced, is by a grievance procedure by the employee saying, I'm concerned that I'm working under these circumstances, and exactly how far that could be taken.
Well, yes, it may be, as old man said, in the real world, the man's union, if it's a unionised workforce, would go to the HSE and complain.
Yes, so the position would appear to be there are a number of options open to the employee whereby he could force his employer to obtain the insurance that the employer is obliged to provide.
One would imagine that in that scenario, when the union have discovered this is a large plant, there's under-insurance, this is a matter of concern, people are doing dangerous work, the company is under the control of Mr. X, one would, certainly in England, expect the injunction application would be made against the company and the individual
Yes.
to have him directly under the court's order.
Yeah.
That again would of course raise, in a slightly different format, the question whether he could, whether the Mr. X could say, well, I'm at risk of committing a criminal offence, I'll take my chances there. CPS a bit slow in England, but I owe no duty to you as a matter of civil law.
Well, Lord Drummond Young certainly does make reference in his judgment. He considers it would be a valid thing for an employee to do, would be to enforce them.
It's not in the real world, it's in the idea that you derive a statutory duty from the possibility that Parliament might have thought it would be useful for employees to claim injunctions against their employers. Seems to me unrealistic. The much more likely course is that it would be a case of all out. You can't expect us to work anymore if you're not insured, and the health inspector would be around next morning. And,
of course, and the employee, if he, especially in a small company like this, it was a one-man business. Right. One would expect saying to the employer, if he's not got insurance, or you hear a rumour he's not got insurance, say, have you got insurance? And he says, no, I haven't. You can vote with your feet and leave. You can say, I'm not working for this chap. But the reality may be dependent upon the size of the business, size of the company. But of course, we see that bigger companies can be more vulnerable to public opinion. Of course, smaller even.
This point about it's not adding anything to the existing liability of the person who's caused the injury doesn't seem to have troubled the court in Monk and Warby. Now, in Monk and Warby, the actual facts was that it was somebody who'd been allowed to drive the car who wasn't so insured. But the requirement, of course, was also to insure yourself when you were using the car.
Yes.
It covered both.
Yes.
And the point that insuring yourself when you were driving the car didn't add anything to your existing liability to the persons you might injure by driving badly. Yes. Doesn't seem to have bothered anybody in Monk and Warby, does it?
It doesn't. I suppose it could be said that the person who was driving the car had a direct obligation just because he had caused the injury.
Well, he does have a direct obligation. So does the employer, having caused the injury in this case.
Well, of course, but the really two sources of obligation on the driver of the car in Monk and Warby. You hit me through your negligence, you caused me injury. There's nothing to be added, nothing to be gained by saying, and you should have made sure you had insurance in place. I'm going to sue you for the same sum. The same way as in this case, there's no point in arguing the same point twice. Let's suppose, for example, the director had been the one who, on that day, had not put the guard on the machine. You would have a direct argument that you are at fault for my accident and I suffered the injury. There would be nothing then to be added by saying, and incidentally, you should have obtained insurance. Because we're just looking for the one pot of money at the end of the day. How we get to it doesn't particularly matter. So the question of interpretation of the statute, I don't think in Monk and Warby they would not be troubled by that, I think, for that particular reason. But in this case, what I say is that there's an enforceable obligation against the company and against the directors to effect that. And that could have been done before the accident if it had been known about. What I intend to do now...
Would liability under the Act be subject to the same limitation period as the direct liability in delict?
I don't think it would have, my lord. My learned friend has pointed out...
We don't need to look at... Or might need to look at...
It would have to be the same, wouldn't it? Because you wouldn't... liability under the Act would be a statutory tort, and there have to be actionable injury, and the injury would be the accident, which the cause of action would arise at the same time.
Yeah.
It would...
I mean, the point about Monk and Warby is that it wasn't dealing with the situation of a claim against the driver, where obviously it is a bit irrelevant to think in terms of whether the driver can be liable for not insuring himself or as opposed to for negligently driving. It was primarily, it was a liability on the owner of the car who permitted somebody else to use it.
But the same point arises, because what we're arguing about is whether the company is civilly liable for not having an insurance policy that the Act requires it to have, and then ancillary to that, the director is civilly liable. But we are principally, I thought the point that we were on about was whether the company was civilly liable. Yeah. And all I'm saying is exactly the same point arose, and exactly the same argument against arose in relation to the driver, or might have arisen in relation to the driver in Monk and Warby, and it doesn't seem to have bothered anybody.
To the decision, yeah, absolutely, lady.
That's all I was seeking.
It's why I said that Monk and Warby is, in fact, on the material issues, indistinguishable in the analysis and the result. One can say, well, I think as Lord Justice Stuart Smith said in Richardson, he said, but it's different because a car is a lethal weapon and you're lending it to someone. Well, I can make the same point that a director is allowing his employee to use a dangerous machine. There's no practical difference.
Well, the difference is in the wording of the statute, namely that it covered a wider group of people, including some people other than the person against whom you'd have an action for negligence. And so the question arose, it was irrelevant to consider whether there would have been an action for failure to insure against the driver if the driver had been sued. But what was relevant was to consider whether there was an action for failure to insure against somebody who wasn't the driver and therefore wasn't liable in tort. And so the wording of the statute covers both.
Well, my submission is there is no material difference if I put it that way for the reasons I've indicated. I'm conscious of the time.
Yes, how are you going? Because you've only got a little bit of time left.
Doing not bad, I don't think. I think the time estimate was down as 1.5 hours.
That's right, yes. Said. So you've got until 12 o'clock.
Well, I'll try and get a move on with it.
Can I just ask you this? In the authorities, you've referred as Professor Campbell Williams. Have you researched any academic literature on Richardson? On Richardson's case, because it receives some comment in Clark and Lunsor, and there's a case note by Janet O'Sullivan in the Cambridge Law Journal about it. I don't know whether you've looked and found any other academic commentary on those cases, this line of cases.
Well, the answer to that is no, other than Lord Drummond-Young makes reference in his decision to some observations about the desirability of insurance being in place. Right. But as far as any academic literature is concerned, there are a couple of articles at the back of the bundle, but beyond that, the answer to the Lord's question is no. My junior's drawn attention to one of the pieces of literature that we have that has been lodged. It's in MS, page number 754.
Yeah, well, I mean, that's
752.
Helpful up to a point.
It is, and in particular, yes, in particular, 754, the very bottom of the page in the footnote, is a reference to Parsons' employer's liability insurance. How secure is the system? Which, if I have a moment.
Sorry, no, this is Peter Kane.
This is Peter Kane.
Yeah. Now, I promised to look at Richardson and then go to the judgments in this particular case. Perhaps if I say this, the way I intend to approach this, especially bearing in mind the time, is this, that the arguments which I think were presented and dealt with in the course of Richardson, and indeed in the Inner House, are arguments I think I've covered most of the bases in my submission here. And what I intend to do is just to very briefly summarise the points that seem to impress the court, unless my lady and my lords consider that that's not a useful exercise. But if one was to summarise the reasons why the majority came to their decision in Richardson, it's broadly speaking that the approach taken was that the Act was not one that was primarily there to benefit the employee. One can see, for example, in what is said by Lord Justice Stuart Smith at MS page number 647. And perhaps if I read just from above letter E, what his lordship said there was, it's accepted in this case by Mr. Hayes on behalf of the defendants that one of the purposes of the Act is to secure that an injured employee does not obtain a barren judgment against his employer. Now, I say that that concession was rightly made, and Lord Justice Stuart Smith doesn't suggest that it was wrongly made. And in my submission, that's almost the end of the case when one pauses at that point. And he goes on, though, to discuss in the next paragraph, if that was the sole purpose of the Act, it might be more force to the plaintiff's argument, which is based very largely upon it. But in my submission, my judgment, it is not the sole purpose. Insurance is normally taken out for the protection of the insured, so that by paying a relatively small premium, he may be protected against a heavy claim or loss. Now, he goes on to talk about the catastrophic injury for an employee, balancing against the benefit to the company in having indemnity against any claim against it. Now, my submission in this is actually fairly short, that if it's right to be looking at the primary beneficiary here, one balances on the one hand the employee who goes to his work and through the fault of his employer, he suffers an accident, and then he discovers, and he's blameless on this hypothesis, he cannot have an enforceable claim against his employer. On the other hand, we have a situation where through neglect, default, etc., in terms of the Act, the director has failed to obtain insurance. And is it right that he is relieved of responsibility when one is balancing fairness as compared to the innocent employee going about his work? So if fairness does come into it, in my submission, the balance of fairness is clearly with the employee. Now, the analysis, particularly by Lord Justice Stuart Smith, who gives the lengthier judgment, is one that goes through a number of pointers that he considers cumulatively point to the result in favour of the employer rather than employee. He does acknowledge that none of them individually would be determinative of the issue, but taken cumulatively, he comes to the conclusion that he does. An exercise that Lord Drummond-Young follows the same pattern, considering a number of individual items, and indeed does Lord Brodie. He follows the same kind of pattern. As far as my submission is concerned in this case, and I don't wish to take the time with the court up reading through all the various analyses, because I think I've covered most of them in my submission. I submit that when one looks, the driving force, and the one that's predominant, is this question of the benefit to the employee. And I say that once that question is answered in my favour, one's almost having to talk oneself out of the position. And I submit that that's not a fair analysis. The question, of course, at the end of the day, is one simply of statutory interpretation. A difficult exercise. I say that when one reads the statute, importantly, in conjunction with the 1930 Act, this package of measures in an unusual situation for insurance being compulsory is one that gives a strong pointer towards the question of parliamentary intention. Unless the court wishes me to go into the detail of the Inner House judgment, I don't intend to do so. But perhaps I can finish by...
Well, it's fair to say that the Inner House departed from a good deal of the reasoning of the Court of Appeal, didn't they? And it might be thought that the Inner House's reasoning was somewhat stronger for focusing on the better points and dropping what might be regarded as the weaker points.
Well, of course, one might suggest that, but one might also say that they've drilled a few holes below the waterline in the reasoning of the Court of Appeal, which I say that they did in this case. The final point that I just wish to make to clarify something is this, that as is recorded in Richardson, there was a search for parliamentary material that might cast some light on the intention of Parliament without really any success. The most that it came to in Richardson was that there was no suggestion that there should be civil liability. I might turn that around and say there was no suggestion there should not be civil liability. And of course, Parliament must be presumed to be legislating against the backdrop of what the common law actually is. We have repeated the futile exercise of trying to find any parliamentary material which is of assistance, with the same result, that we can find nothing that would give some assistance to this court.
Has there been any move since Richardson and Pitt Stanley to reverse it by legislation?
No.
Has the Law Commission looked at it?
There hasn't been. And my learned friend makes the point that although there have been amendments to the, in particular, I think the 1930 Act, and amendments indeed to the 69 Act, that there's been no move to amend. My only response to that can be this, that Parliament, in my submission, without a very strong driving force to say there's a terrible error here, there's something that should be changed or clarified, one has to take it for what it is. And in my submission, although it may be thought to be something of a fiction, one shouldn't read too much in the fact that it's not been amended to correct the position in Richardson. One questions, at the outset I said that this may affect a large number of people, but one questions exactly how many cases this particular problem has arisen in. There's not the same driving force that there might be in, for example, mesothelioma cases, where there was a feeling in Scotland that the law should be changed by Parliament to rectify something that was felt a decision of the courts was wrong. So accordingly, in this case, there has been no attempt to change it. But I say that the common law is what the common law is, and therefore the pursuer should be successful. Unless there's anything I can assist on at this stage, I respectfully make the motion that I made at the outset.
Thank you very much, Mr. Smith. Mr. Dunlop.
My lady, my lords, I'm obliged. Can I start by noting that, as was remarked by Lord Reid in his exchange earlier with my learned friend, this case does all turn on parliamentary intention. The root question is whether or not a consideration of the 1969 Act leads one to the conclusion that Parliament intended to impose civil liability on a director or other corporate officer, because bear in mind, it's not just directors we're talking about here, a director or other corporate officer who contributes by act or omission to a corporate failure to insure. This is in truth the only question. For the reasons set out in the written case, we are not talking here about a case in common law. Notwithstanding what was said by Lord Kinnear in the Black case, this is not a common law case. Such a case was attempted by the pursuer at first instance, was rejected by Lord Glennie, was amended out of the pleadings by the interlocutor of 30th January 2014, and isn't there anymore. We're only talking about the question of whether or not there is here a breach of statutory duty. Now, as has been said before, the one law that this court can do nothing about is the law of unintended consequences. And in my submission, this court should not be seduced into attempting some sort of third way that doesn't rely on common law negligence or on the understanding of a statutory tort. And in the search for parliamentary intention, there are multiple factors which, in my submission, point firmly away from the imposition of personal liability on a director or other officer of the company. Can we start by going back to the Act, tab 1 of the authorities, page MS 137. And the heading tells us that this is an act to require employers to insure against their liability for personal injury to their employees. That's the purpose of the Act. And it goes about it in section 1 by saying that every employer must carry insurance. Now, this is why in the written case for the respondent, paragraph 3.5, without needing the court to go to it, the reference is paragraph 3.5, MS 41. We look at the question posed by Lord Simons in Cutler, where he said it's often a difficult question whether, where a statutory obligation is placed on A, B, who conceives himself to be damnified by A's breach of it, has a right of action against him. In that question, A is the employer, not the respondent. The obligation to insure is cast upon the corporate employer. As we then look through the Act, Section 1, subsection 3 contemplates that there will be an approved policy. And what Section 1, subsection 2, regulations may provide that the amount for which the employer is required by that Act to insure may be limited. And in fact, we know it is limited because when we see what's now in force, it's Regulation 3 of the 1998 regulations, page MS 148, the limit is £5 million, and not £5 million per injury, not £5 million per employee, but £5 million per occurrence.
Sorry, where was this?
It's page MS 148, my lord. It's in the
The regulation.
the regulations. Regulation 3, so the amount for which an employer is required by the Act shall be in aggregate be not less than 5 million in respect of a claim relating to any one or more of those employees arising out of any one occurrence and any cost or expenses. So it's a claim of £5 million per occurrence, not per injury, and it includes all the costs and expenses. Now, the point I take from that is the Act is not contemplating a guarantee that the injured person will have cover.
I'm not sure about that. 5 million in respect of a claim relating to any one or more. I see. So
Arising out of any one occurrence.
it postulates you can have a claim relating to more than one employee.
Yes.
Normally, one would talk about it as several claims then, rather than a claim.
Well,
Has anyone ever decided that this imposes an overall liability?
Well, I'm just looking at what the regulation says, and I'm having in mind something like the stock line explosion, for example. So that would be the one occurrence. There could be multiple claims arising from that. But even if we ignore the multiple claims point, the limit is £5 million, and it's well known that claims for catastrophic injury can be well over that.
It's a minimum, not a limit.
Yes, but the employer satisfies its statutory obligation.
Yes, I understand that.
If it takes that out.
I understand that,
Yes.
but
It's a distinction between the motor insurance situation where the cover has to be unlimited. Then if we return to the Act itself and to Section 4 of the Act, this is the provision dealing with regulation of the obligation to insure, requiring the display of certificates, allowing for inspection by the Secretary of State, and the regulations then follow that through and say the Secretary of State can, through his officers, demand sight of certificates, demand sight of the policy. This is, as my learned friend frankly acknowledges, a regulatory scheme designed to allow for enforcement of the obligation to insure. When asking how the scheme is enforced in the real world, how Parliament intended the scheme to be enforced in the real world, Section 4 is the answer. With the compositor being Section 4 is itself punishable under criminal law, and Section 5 also criminalises the failure to insure itself. So how is this all enforced? It's enforced by officers of the Secretary of State. It's enforced by the criminal law. If one stopped at Section 4, my learned friend's case would not be arguable. The sole duty is cast on the employer, and it's trite that for a corporate employer, the director is not the employer. So he frankly recognises that his case is perilled on Section 5. We then look to Section 5. The heading is penalty for failure to insure. Penalty, not liability, not duty, not obligation, penalty for failure to insure. A word which points very strongly, exclusively I would suggest, towards criminal liability. And we then read Section 5 saying, an employer who on any day is not insured in accordance with this Act when required to be so shall be guilty of an offence and shall be liable on summary conviction to a fine not exceeding level 4 on the standard scale, presently £2,500. And then, so that again, thus far, there's nothing to assist my learned friend. So his case is perilled on the last part of Section 5. And where an offence under this section committed by a corporation has been committed with the consent or connivance of or facilitated by any neglect on the part of any director, manager, secretary or other officer of the corporation, he as well as the corporation shall be deemed to be guilty of the offence and should be liable to be proceeded against and punished accordingly. This is all directed towards criminal liability. It has nothing to do with civil liability. The starting premise is that the company has committed an offence, not that it's in breach of duty. The next is that the offence has been committed with consent, connivance, or neglect. Now, those words, consent, connivance, or neglect, upon which the appellant's case is perilled, are commonplace. A Westlaw search for the use of this provision imposing criminal liability on directors for corporate breaches reveals 984 instances in which this statutory mechanism is used. And what's the purpose of it? The purpose is to enhance the deterrent. That was explained most coherently in my submission by Lord Normand in the Cutler case. Cutler is at tab 10, MS 315.
Where does he deal with this?
So the statutory provision itself that Lord Normand is commenting on was actually quoted by Lord Simons, and if the court turns to page 406 of the original report, MS 323, and it's at the top of that page, second line down, section 29 of the Act then under consideration, where a person convicted of an offence under this Act is a body corporate. Every person who at the date of the commission of the offence was a director or officer of the body corporate shall also be deemed to be guilty of that offence unless he proves that the offence was committed without his knowledge. So in fact, that was a stronger prohibition in that case because it said you're guilty unless you can prove otherwise, as opposed to here, the burden would rest on the prosecution to prove consent, connivance or neglect. And Lord Normand addressed the point of that at page MS 331, original page 414. And on the larger paragraph on that, the only full paragraph on that page, His Lordship is considering the content of the statute then under consideration, and about 12 or 15 lines from the bottom of the page, His Lordship says, their deterrent effect is, however, very much increased by the provisions of Section 29, under which a director or officer of a body corporate may be deemed guilty of an offence of which the body corporate is convicted, and still more by the power given elsewhere to withhold or revoke the licence required by the operation of a racing track if the applicant or licensee has been convicted of a contravention of the provisions. The penalties, therefore, are an unusually effective sanction for the enforcement of the sections of the Act to which they relate and stand in no need of aid from civil proceedings. And I say that exactly the same analysis applies here. Now, I've mentioned the multiple instances of this statutory mechanism having been used. The same statutory mechanism is found in the legislation under consideration in Lonro, in which there was no suggestion by anyone that it resulted in liability falling on the directors. Lonro is the authorities at tab 15, and the relevant page is MS 513. And also in the case of Wong, it's the case from the Solomon Islands that I'll come back to in early course. And the very same statutory provision, consent, connivance or neglect, is found in the Act considered by this court in Morrison Sports. The Electricity Act of 1989 contains exactly the same provision at section 108. This is therefore a commonplace statutory mechanism imposing criminal liability for deterrent effect. The same Westlaw search reveals no instance in which that statutory mechanism has been suggested, let alone held, to import personal liability on anyone except from the minority, decisions that we've looked at in Richardson and in this case.
So you said one finds it in Morrison as well.
It's actually not, it's not referred to in Morrison at all. No one even relied on it in Morrison. I simply observe, my lord, that if one looks at the Act that was under discussion in Morrison, the Electricity Act, 1989, one finds precisely the same statutory provision at section 108. And no one even thought it bore mentioning. None of the very experienced counsel or judges in that case thought that even bore mentioning. And of further interest, given the commonplace use of this mechanism, is that the same mechanism was found in the Factories Act 1961, section 155, subsection 5. There are not many acts of Parliament that have engendered so much litigation as the Factories Act 1961.
Which was the section again?
Section 155, subsection 5. And there has never been any suggestion that a director is, by consent, connivance or neglect, personally liable for a breach of the Factories Act. So if the effect of this statutory mechanism is to pierce the statutory veil, the corporate veil, by making directors personally liable for the civil consequences of corporate breach, then that seems to have gone unnoticed since this type of provision was introduced in the 1930s. Meanwhile, of course, this court has emphasised the limited circumstances in which the corporate veil will be pierced or lifted. And the court will be very familiar with it. I simply refer to the case, the Prest case, authorities, tab 18. So if we return to the law of unintended consequences, the statutory provision upon which...
I'm sorry. Before we go on, we were referred to the Health and Safety at Work Act 1974,
yes,
which does have a similar provision about offences by bodies corporate.
Yes.
But it then has a provision which says no civil liability.
yes.
Do we know how many of these 900 or so cases that you're mentioning are accompanied by a similar provision excluding civil liability?
The Health and Safety at Work Act is the only one I can find.
Is it? I see.
It is. And this comes back, it's a point that Lord Tilson made earlier. It is an irony that in all of these cases, one is having to discern what Parliament intended when it didn't say that which it could so easily have said.
Well, Lord Duparc sounded off on that.
Indeed, I was going to refer to that, my lord. It's
Oh, well,
Lord
you
Duparc
carry on.
in Cutler. And it is a surprising point, is it not, that when Lord Duparc so sounded off in 1949 and was joined in, I think, by one of the other members of the Appellate Committee, that one would find in legislation after that, when Parliament is meant to be taking account of decisions of the House of Lords.
But Lord Duparc went on to
Likely
say,
story.
the passage you have in mind is at MS 327.
That's correct, my lord, yes.
When did you want to go to that?
Well, I'm happy to do now.
Okay,
I'm going to do it
just-
slightly later. I'm happy to go there now.
Just before you do, and just before we leave the 1974 Act, can you help me with this? Is Section 47 excluding civil liability only in respect of certain provisions of the Act?
It is. And, of course, the interesting point about this is that Section 47, as originally enacted, said breach of regulation, Section 47(2), breach of regulations is actionable at civil law unless the regulations say otherwise.
Yes.
But of course, what we have now, and that's why two versions of the Act are given, since the Enterprise Act came into force, we now have the situation where regulations are not actionable at civil law unless they say otherwise.
Yeah, so it's on either version. You had a situation where the Act was adopting a rather complex provision and a complex position in relation to civil liability, with some of its provisions intended to give rise to civil liability and others not.
That's correct. And so sections 2 through 7, for example, have always not been actionable at civil law. Regulations for a while were and now are not. And the point I make in that is there's somewhat of an irony if this court were to say parliamentary intention is that you find civil liability in this Act when parliamentary intent seems to be swimming in the completely opposite direction, in that you don't even have actionability for breach of health and safety regulations by the employer itself. So there's no actionability for the original breach. One has to show common law negligence, but there is a breach of statutory duty for failure to insure.
Yeah.
Right, now, wait a minute. The bit in the Health and Safety Act, when was that enacted?
That's per the Enterprise Act 2010, my lord. Didn't come into force until 2013.
You have to be a bit careful about using a 2010 Act to construe a 1989 Act.
I'm not saying that, my lord. All I said was, all I observed was, there is an irony if this court is going to say, here's the parliamentary intention in 1969, when the parliamentary intention since then has been swimming away from that. In particular, given that since 1995, there has been a decision binding on all courts in England and Wales except this one, saying this is not actionable. And Parliament has amended this Act time and time and time again and has done nothing to reverse the effects of Richardson against Pitt-Stanley.
What did you say, this Act, the Health and Safety Act?
No, the 1969 Act.
The 1969 Act.
If the court looks at the Westlaw print, there are multiple amendments of the Act, multiple amendments since 1995, with Parliament never stopping to say, hold on, that's not what we meant. Surely you understood when you looked at the 1969 Act. This was personally actionable against directors and officers and managers, etc. I was winding up this particular point by returning to the question of the law of unintended consequences. The statutory provisions which we're looking at the moment are in truth vanilla legislation. There is no specialty in them at all. And if this is enough to impose personal liability, then that will apply in a variety of other scenarios, and not just for directors, for officers, for managers, for secretaries, and the like. It's so commonplace that it would involve the removal of the corporate veil in Northern Ireland entire. And I say that because this statutory mechanism, consent, connivance, or neglect, applies automatically to all corporate offences in breach of statute as a result of the Northern Irish Interpretation Act of 1954. which imports this statutory mechanism by default under section 20, subsection 2, to all statutory obligations in the province.
Where do we find that?
It's the Interpretation Act, Northern Ireland, 1954.
Where is it?
Section 20, subsection 2. I'm sorry, my lord, it's not produced. I can make a copy available. It's not
Section
produced.
20.
Section 20, subsection 2.
So it implements this, or it introduces this formula, sorry, with what effect?
It says that this consent, connivance or neglect position is imported as a default into every breach of statutory duty by a corporation.
So that there is always a statutory penalty in respect of officers.
Yes.
Whenever a corporation breaches a duty. What is the penalty? What's the maximum? Where are the penalties?
It is the. I can give the court the precise statutory wording if that would help, or I can simply make.
Could you give me the name of the statute again?
It's the Interpretation Act, open brackets, Northern Ireland, close brackets, 1954, at section 20, subsection 2. And I'll simply make the wording available per those instructing me for consideration, rather than trying to.
This applies where there's a penalty imposed on a corporation.
Yes.
And then there's deemed liability on the directors.
Yes. The precise wording is that where an offence under any enactment passed after the commencement of this Act has been committed by a body corporate, any person who at the time of such commission was a director, general manager, secretary, or other similar officer shall be liable to be prosecuted as if he had personally committed that offence, if it is proved to the satisfaction of the court that he consented to or connived at or did not exercise all such reasonable diligence as he ought to have, having regard to the nature of his functions, be liable to like conviction and punishment as if he had personally been guilty of that offence. So it's basically the same statutory mechanism that is used here, and it's imported to any case of corporate breach in Northern Ireland.
This seems to be a new point, isn't it? I mean, this point that this formula is used in hundreds of different statutory contexts, and so that any decision we make about its effect would have wide-ranging implications. Is that a new point being made now?
Frankly, my lord, the reason where certainly the Irish aspect of it comes up is Milena Jr. yesterday observed that the 1969 Act doesn't apply in Northern Ireland. There is an equivalent Northern Irish order imposing the 1969 obligation. And the one notable difference is that it doesn't have the second part of Section 5. So we were struggling to understand why that was.
And now you know.
And now we know. So, frankly, yes. Yes, my lord.
No,
but it's coming back to my general point about the law of unintended consequences. It is one that the court needs to take into account.
But of course, that all depends upon whether one is looking at the particular obligation imposed upon the company.
It does.
And whether the obligation imposed upon the company is such as to attract civil liability. And if that is the case, well, then there may also be the ancillary or parasitic liability on the part of the people running the company. It doesn't follow necessarily. Of course, it would depend upon the way in which the judgment was expressed, but it doesn't follow necessarily that it would have the same effect in all of these other acts of Parliament where the breach of the statute wouldn't necessarily result in civil liability anyway.
It doesn't. But the point I make is that we have such a widespread use of this particular mechanism without any court ever having held that it imports personal liability. The suggestion that it does is a difficult one to countenance. And that particularly when we have in mind what was said by this court in Morrison Sports. And I have in mind here what was said by Lord Roger giving the opinion of the court. This is paragraph 16 in Morrison, Authority tab 17, page MS 637.
537.
Sorry, 537, Your Lordship's quite correct. Second sentence of paragraph 16, there is no basis whatever for thinking that the drafter of the provision intended to introduce a civil right of action, but somehow botched that comparatively straightforward task and came up with words in the subsection which are so singularly ill-suited to the supposed purpose. That, in my submission, is what one has here.
Order the
Well,
word.
that's just a bit of typically strong language about the construction of a completely different statutory provision.
Well, in my submission, it applies directly when one looks at the words used here. You couldn't get words that are further removed from words designed to import civil liability on the part of a director.
Of course, Lord Roger then went on to look at the matter in terms more of general principle and under reference to the Bedfordshire case. And it's interesting that paragraphs 30 to 32, he emphasises the importance of an enforcement regime involving inspection by inspectors appointed by the Secretary of State, and in fact considers an argument that that there might be a civil liability to enforcement by way of interdict or the like, and is rather dismissive of that on the footing that Parliament's provided what the scheme for enforcement is to be.
Precisely so. I mean, I say exactly the same applies here. It is about the real world. How did Parliament expect in the real world the duty to insure to be enforced? We have it in Section 4 and Section 5. The suggestion that it would have to be an action for specific implement because the order that would be sought would be a positive order, it couldn't be an interdict. The suggestion that employees would be running off to the Court of Session for an order for specific implement doesn't really bear any resemblance to the real world. And immediately one would envisage the court saying, well, hang on a minute, I'm only going to grant this if there's not another remedy already provided for. And there is a remedy already provided for, which is go and speak to the Health and Safety Executive. And if they don't do anything about it, go and speak to the Procurator Fiscal.
Yes, that's really his conclusion of paragraph 37 in relation to the act he was dealing with.
Yes, absolutely. And Morrison is important. Morrison is the most recent word of this court on how one gets to parliamentary intention. And I will come back to it in short order. But just before we pass from the nature of the liability here, because my Lord Reid asked the question, would it be subject to the same limitation process? It wouldn't in my submission. As long ago as in 1945, in Fleming against McGillivray, that's the case that's at Authority tab 13, the Inner House recognised that the original breach of hurting somebody and the loss flowing from a failure to insure against that injury are two different concepts. They're different losses. They're obviously different losses if one has in mind here a limitation to insure for 5 million and the unlimited liability that would arise for the original injury. And it is, as the court in both Richardson and in this case recognised, this is pure economic loss that one is guarding against here, if that is what the court decides. So the court has to hold that Parliament intended to create a cause of action to guard against pure economic loss in 1969. That cause of action is subject to the quinquennial under the law of Scotland. This is not, insofar as Mr. Gordon faces a claim based on failure to insure, that is not a claim for personal injuries.
What happens if you have, say, the employee is injured in a road accident between his employer's van and a third party's vehicle, and the employer isn't insured, and he has a claim against, say he recovers against the director of a company for the amount of his loss. What then happens in relation to contribution between what sort of claim, if any, does the director then have against the other party who was involved in the accident?
Well, I guess one would have to follow through the steps as the court suggested must be done in Fleming. The first question is there a primary liability? It's the liability for the injury. So that would turn on whether or not there was sole fault on the part of the corporate employee in the accident, or was there a joining fault on the part of the driver.
The director isn't responsible for the accident.
Exactly. And that's really the point, isn't it? Because we have this very odd situation that what is trying to be done is to say, well, we need to protect the employee, so we'll impose this duty to protect against pure economic loss. But there's no attempt, there's never been an attempt to introduce personal liability at the earlier stage, protect against the injury itself. Because it's never been the case, it has never been our law that a director is personally liable for a corporate breach of statutory duty towards an employer.
There wouldn't be a common law claim for relief because it's not the same debt, it's not the same obligation.
That's correct.
I'm just wondering if would there be a statutory claim for relief under the 1940 Act?
Well, I think, but before one got there, then is your lordship envisaging a situation where both drivers are at fault?
Yeah.
So the pursuer would say, I will sue both of you drivers. Now, unless they're both uninsured, that's not a problem, because joint and several liability is going to allow the pursuer to recover all of it.
Yes. I was just wondering if a civil liability, what problems a civil liability of this kind we're being asked to find would create in a not particularly complex situation.
Well,
and I was envisaging the employee recovering against the director of his employer for his economic loss in being unable to recover damages in delict against his employer because there was no insurance and the employer was insolvent.
Yes.
And so he recovers he recovers his economic loss from the director on the basis of a breach of statutory duty. And I'm wondering whether the director then has any claim for relief or indemnification or anything of that kind against the other driver. And he certainly wouldn't have common law.
I can't think of any basis.
I'm not sure if he would under statute either.
No, I can't think of any basis upon which he should, because, as my lord has observed, this is pure economic loss. If that's what this court is going to do, it must understand it is imposing liability for pure economic loss, with all of the consequences that has. And given the state, going back to Lord Tilson's point when he quite correctly says to me, well, you can't test this by looking at what happened in the Enterprise Act 2013. Well, let's look at parliamentary intention in 1969 and how the law of pure economic loss had developed by that stage. Now, the answer against me is, well, Monk and Warby effectively imposed that liability some 39 years earlier. But as we come to see, when we look at Monk, that actually provides a very slender foundation for the attempt which my learned friend seeks to build upon that very case. But accepting that at the very least, an aim of the 1969 Act is to protect employees. And I'm not going to be foolish enough to joust with Lord Mance on that point. Accepting that that is at the very least an aim, that isn't of itself enough. My learned friend's analysis, based on Black and Lonhro, needs to be read in light of more recent authority, because picking up on what was said by Lord Malcolm and on the observation from my Lord Reid earlier, one needs something more. The reason why is found in Morrison. I'll come back to that, but it's also given by Professor Stanton in his work on statutory torts, Authority tab 25, and it's page MS 755. Now, at paragraph 2019, the first indent of that, Professor Stanton is discussing what was said by Lord Diplock in Lonhro. And he goes on to say, the operation of this presumption is stated by Lord Diplock to depend upon whether the statutory obligation in question was intended by Parliament to benefit the interests of the public or of a defined group of members of the public. In subsequent decisions, the House of Lords has emphasised that this is unacceptably vague. The approach which is now accepted is that what is to be searched for in the legislation is a parliamentary intention, not merely to confer benefits on the members of a defined class of persons, but is one to confer enforceable private law rights sounding in damages on such persons. There is a distinction between a statute which provides protection or other incidental advantages to the members of a defined class of society and one which is intended to confer rights to claim compensation upon them. Looked at from this perspective, Lord Diplock's description of the presumptions in Law Note is incomplete and potentially misleading. By denying the proposition that the discovery of a class of persons who benefit from the duty on its own creates a presumption of actionability, the courts have undoubtedly created a significant barrier to the recognition of examples of the tort. This modern approach is one which confers a considerable discretion on the courts, which have to seek this requisite intention. It is one which has generally been exercised to deny the existence of the tort. The modern approach stems from the decisions of the House of Lords in Hague and in Pickering. In Hague, the plaintiffs alleged that breaches of the prison rules made under the Prison Act of 1952 were actionable in their favour. In the course of rejecting the claim, Lord Jauncey summarised the position in words regularly cited in later cases. It must always be a matter for consideration whether the legislature intended that private law rights of action be conferred upon individuals in respect of breaches of the relevant statutory provision. The fact that a particular provision was intended to protect certain individuals is not of itself sufficient to confer private law rights of action upon them. Something more is required to show that the legislature intended such conferment. And it's that something more which the majority in this case found missing. And it's that something more which in my submission is here missing. The additional factor can't be Section 5, because Section 5 is the only basis for the pursuer's claim. The need for something more is also underlined in the discussion in Morrison. We've already looked at this, and in particular, Lord Reid has pointed me to the points about the regulation, the regulatory scheme. And if we turn to the decision of the court at paragraph 41, MS 543, what was said was, as support for their view that the regulations gave rise to a private right of action, the extra division attached some weight to the fact that the aim of some of the regulations is to reduce the risk of personal injury or damage to property. Even if that is a consideration which can, in an appropriate case, point to an intention on the part of the legislator to create a private right of action, and pausing there, that's not the aim that can here be in play, because we're talking about pure economic loss, but passing from that distinction, even if that is a consideration, the mixed aims of the 1988 regulations weakens any argument of that kind in respect of them. And here I say there are mixed aims, because part of the aim is to protect businesses from going under. That was held in Richardson in my submission. That is part of the aim behind the legislation. But in any event, the court goes on in Morrison, in any event, the fact that legislation is designed to reduce the risk of personal injury or damage to property is by no means an infallible indication that Parliament intended to give individuals a private right of action for breach of its provisions. It is simply one factor to be taken into account. And when one puts that together with what was said by Lord Jauncey in the Hague case, we see that something more is required. And that, in my submission, does explain why the appellate authorities in this area favour the respondent. I've already observed that Richardson has stood without legislative interference for 20 years. There's also the decision in the case of Wong that I said it would come back to, tab 21 in the bundle. a decision of a court with which I confess I have very little familiarity, the Court of Appeal of the Solomon Islands, but one sees very eminent judges involved in that court. And we have the court presiding.
In New Zealand judges, but I see on this occasion Lord Slynn sat. Which
Indeed. So we have Lord Slynn of Hadley, we have Justice of Appeal Williams, who was actually at the time a judge of the Court of Appeal of Queensland. And we have Justice of Appeal Ward, who was not, as I first thought, Lord Justice Ward, but rather the former Chief Justice of Tonga and the President of the Court of Appeal of Fiji, although an English-trained lawyer. So very familiar with the law of the Commonwealth, all three of them. And what one had in that case was effectively the Richardson situation, but with the addition that the Act specifically imposed civil liability on the employer. And in that case, we have the same statutory provision. So if the court turns to MS 671, in the middle of that page, we see that by Section 43, if an offence has been committed by a body corporate, any person at the time of the commission of the offence as a director, manager, etc., he, as well as the body corporate, shall be deemed to be guilty of an offence unless he proves the offence was committed without his consent or connivance, and that he exercised all due diligence to prevent the commission of the offence. So again, it's a slightly stronger criminal prohibition. It says you're liable unless you can prove otherwise. And there was an attempt to argue that, well, what you've got here is definite civil liability on the company. You've got a deeming provision making the directors guilty. That must be enough, the argument went, to impose civil liability on the directors. But no. Lord Slynn, giving the opinion of the court, if one turns to MS 673, third last paragraph, we bear fully in mind the purpose of the creation of the fund, but we also remember the general rule restated in Law and Row that where a statute creates an obligation and enforces performance in a specific manner, that performance cannot be enforced in any other manner. The two exceptions referred to by Lord Diplock do not apply. The objection here was imposed on the company and can be enforced as prescribed. It was not imposed on the directors. And that, as I say, is a situation where there can be no doubt that there was civil liability on the part of the company. And Richardson has dealt with shows that where a breach of statutory duty results in criminal liability, it's a question of construction. Whether by express a provision or necessary implication, civil liability also arises. In that case, it was held there was no civil, but only criminal liability on the company and the directors. Here it is different. There is an express civil liability on the company and none expressly on the directors. So Wong was a stronger case for the claimants, and it failed. And it failed in the face of three very experienced Commonwealth judges. The points which have weighed with the appellate courts thus far should weigh strongly with this court. The starting point is that the imposition of duty is imposed on the employer only. There is no case before this court, there is no case which researchers have revealed, whereby a claim for breach of statutory duty has succeeded without that duty actually being cast on the defender himself. Here, the statutory obligation in Section 1 is expressly imposed on the company and the company only. And what Section 5 does is not even say that the director commits an offence in certain circumstances, rather that he is deemed to be guilty. We are several steps removed from any situation where courts have recognised actionable statutory duty. Now, dealing with the point that resonated so strongly with Lord Brodie, and the point which has been raised by my lady in the chair, It must be necessary, before one gets to liability on the part of the directors, surely, that there be civil liability on the part of the company. So one must be able to discern first the imposition of civil liability on the company. Well, in my submission, and this harks back to what I said earlier about enforcement, Lord Brodie was obviously correct when he said that would be a palpably redundant, worthless, illusory sort of right. The company is already ex hypothesi liable for the original injury. If it's got the assets, no problem. If it hasn't, the imposition of the supposed duty adds precisely nothing, unless one is going to give credit to the proposition that the employees are running off to court for specific implement, notwithstanding the enforcement regime specified by the Act itself. Ultimately, perhaps the strongest analogue that the appellant can find is in Monk and Warby. But on close examination, that analogy is flawed. The court's already observed as to perhaps the most important distinction. Monk is found in Authorities tab 16 at page 520, MS 520. And just looking at the front page of the report, the statutory provisions then in play are found in the footnote at the bottom of the first page. It shall not be lawful. So already we have words that are not found in the 1969 Act. It shall not be lawful for any person to use or to cause or permit any other person to use a motor vehicle. Now this did add something, a very obvious and useful something, to the remedy open to Mr. Monk, because the driver that had injured him wasn't good for the money because he wasn't insured. But he could go against the person who owned the car and who caused or permitted the use. That's why in Monk and Warby there's no discussion about, well, this is useless, because the very obvious second remedy was available there. It's not the same as a situation where you have the corporate liability and then some sort of parasitic director's liability. They're two different people. And importantly, the duty that was actionable was cast directly on the defender himself. It shall not be lawful for any person to cause or permit any other person to use. But moreover, when we look to Monk itself, page 81 in the opinion of Lord Justice Greer, just below halfway down the page, his lordship said, the result of the above construction may be stated as follows. Prima facie, a person who has been injured by the breach of a statute has a right to recover damages from the person committing it, unless it can be established by considering the whole of the Act that no such right was intended to be given. That is an inversion of the rule explained in Hague and set down authoritatively by this court in Morrison Sports. And the same approach is found in the speech of Lord Justice Maugham at page 85. That involves looking at matters through the wrong end of the telescope. One also sees...
It was approved, Monk and Warby, in Cutler and Wandsworth, wasn't it?
It's certainly cited with approval.
Right.
Yes. That is the case. But, importantly, the two dicta we've just looked at about the prima facie aspect does not square with what was said in Hague, does not square with what was said in Morrison.
Well, that does raise the question whether Morrison is to be read as departing from a line of authorities, Cutler and Wandsworth, Lonhro, Grosvenor or Wimborne, because Morrison builds on Ex and Bedfordshire. In Ex and Bedfordshire, the paragraph we've looked at in Lord Brown Wilkinson's speech, he cites 3 cases as setting out the law: Grosvenor, Wimborne, Cutler and Wandsworth, and Lonhro. Now, query, whether he was actually intending to depart from the collective effect of the 3 cases which he cites as setting out the law. And therefore we do perhaps need to look, although it's such a familiar case, at those cases, including Cutler and Wandsworth, in which you recognise that Monk and Warby was cited with approval.
But what we then have, my Lord, is that first of all, there's the point I'm about to take the court to, that not only does the approach described by the Lord Justices in Monk fly contrary to Morrison, there's express reliance on a dictum which has been disapproved in Morrison. So that is the most recent word on the issue from this court. And that means that Monk is, and I don't need to say, and I haven't said in the case that Monk should be overruled. All I say is Monk is distinguishable. No, and Monk provides a very...
Case, what is now coming into sharp relief as a result of rival arguments is that we must address the question whether there has been a conscious shift by the courts away from Grosvenor, Wimborne, Cutler and Wandsworth and Lonhro.
And in my submission, the answer to that is the one given very clearly by Professor Stanton, under reference to what was said in Hague, what was said in Pickering, what was said in X.
Because if there has been, it's not, it's been unexpressed rather than deliberate. I mean, it is not, there's no statement. We now think that those authorities need to be revised. It is a change under the rubric of following them.
Well, what I would say about that is, my Lord, under reference to Morrison Sports and the point we've just looked at, the only question that ever matters in this is what was the intention of Parliament. And what Morrison Sports says is, you can't just start by saying, well, this is put in for someone's protection, therefore...
And that comes round to the question, how do you devise the intention of Parliament when Parliament has been silent on the subject?
Indeed.
And the traditional way has been to say, you look at the overall purpose of the statute, the underlying object of it, and then you have certain rules of thumb which may be displaced. I mean, that's Cutler and Wandsworth spelt that out extremely clearly. Now, if you depart from that, but you have got a void as to Parliament's intention, how on earth do you solve Lord Duparc's riddle? I mean, Lord Duparc set the riddle and provided the answer to it. But you say the answer to it's wrong, and I'm not clear what the substitute answer is.
One solves the riddle in my submission by posing the question that I referred to right at the outset of my submissions. It's the question posed by Lord Simons. When a duty is posed on A and B claims to be damnified by the breach of that duty, it is often a nice question whether or not that duty is actionable at the suit of B.
But I think when you're looking carefully at what Lord Simons said, you're actually saying, no, the law's moved on from there. Nous avons changé tout cela.
Certainly, in terms of Morrison, there is perhaps a quantum shift in all of this. But the starting point is, can one find the duty imposed on A? And the duty here is not imposed on Mr. Gordon at all. It is expressly imposed upon the company.
I thought Professor Stanton's analysis was quite helpful in contrasting the older dicta, which asked whether one could see an intention to benefit or protect a particular class, and treated that as being an important factor. and the way Lord Jauncey had put it in the Parkhurst case, and other judges subsequently in this court and the House of Lords, saying, well, this isn't really so much whether one can discern an intention to benefit as an intention to confer a right to compensation. And it's a more precisely focused inquiry.
It is, and in that regard, there is in fact no dissonance between Cutler, because in Cutler the court recognised that, of course, the bookkeepers who are complaining here are beneficiaries of this.
I think they were bookmakers, weren't they?
Bookmakers, yes.
Yes.
The bookmakers, a slightly different species.
Exactly.
The bookmakers were beneficiaries of the very statutory obligation, but that didn't mean that there was a statutory intent to create a right for compensation.
What I'm grasping for is this. If Parliament has provided a particular sanction, penal sanction, but it hasn't said whether that's intended to be the exclusive method of enforcement, how does the court decide whether it was intended to be exclusive or not? You say the modern authorities say that's what you've got to concentrate on, but in the face of Parliament's silence, how does it do it? In the older authorities, they approached it by saying, our general starting point is that if it specifies a penal remedy, that's it, none other is intended. But there are two clearly recognised categories where that's not so, and one of them being Groves and Lord Wimborne. Lord Norman says, well, as long as Parliament chooses to maintain a holy silence, it must be taken to expect the courts to apply the canons of construction they have. Now, you sweep that aside, how does the court now, in the brave new world, decide whether Parliament intended it to be an exclusive remedy when it has chosen to remain silent? How do you do it?
It's very difficult. But one has to.
It may be difficult, but give us a help.
One has to apply. The best approach I can give is that which is said by Professor Stanton under reference to the dicta in Hague and in Pickering and in X, and I graft onto that the approach in Morrison.
Well, you have really to go to Morrison, don't you? Because all of the three cases on which Professor Stanton relies, they're all public law duties on public authorities.
Yes, well, certainly the Prisons Act was pretty clearly put there to protect prisoners.
Yes, I understand that, but they were duties on public authorities.
Oh, yes, absolutely.
And there really is not a lot of doubt from the approach of Lord Brown-Wilkinson in X that he was placing a very considerable reliance on the fact that these were public authorities.
Yes.
And of course there are other
employees of
and so on. So
social workers as well, of course, employees of public authorities who were sued in.
yes, and of course we've changed that law now. So
yes.
Least said, possibly.
Yes.
But all I'm getting at is that those particular cases have to do with public authorities. And actually, of course, in Morrison Sports, they were dealing with obligations that were originally placed on public authorities before privatisation of the electricity supply industry.
It's all about the regulatory world, wasn't it?
It is, but there is a regulatory scheme here deliberately imposed by Section 4. So that is also highly relevant in all of this.
With a view to ensuring that employees who are injured by their employer's breach of duty are compensated.
Well,
that's the purpose of the scheme.
I've already accepted, my lady, and I'm not going to depart from that acceptance. That at the very least, an aim of this is to provide that there will be insurance available for injured employees. But that's not...
In order to secure that they are compensated for
yes.
the injuries that they suffer.
Yes, so that's the protection. The protection is against economic loss, which they will suffer if they can't recover the money for the damages. But that is not enough. Something more is needed. That's Lord Jauncey, that is Morrison Sports. And what I say is missing is that something extra. I was dealing with Monk, and just before we break, if I can, I also mentioned that there is reliance in Monk on a dictum which has been expressly overruled.
Which is that?
So if we go back to Monk, it's page 82 in Monk, which is MS page 527.
And you're not, I mean, as I understand your submission, you're not just pointing to the absence of something extra. You're saying that there are also here a number of factors, the fact that it's economic loss, the fact that the result would be an important qualification of limited liability, and so forth, which you say are all the more reason for Parliament to have been rather somewhat clearer than it has been if it had been its intention to do this.
Absolutely, my lord. I'm not saying they haven't quite got there, so they lose. I am saying, in the search for something more is needed, it is a failed search. But then, let's look at everything else.
So it's the Lord Justice Atkin dictum.
It is the Lord Justice Atkin dictum. Your Lordship's quite correct.
In Morrison, it's mainly to do with the public aspect, isn't it?
Well, one question to be considered is, does the
general-
Act contain a reference to a remedy for breach of it? Prima facie, if it does, it's the only remedy, but it's not conclusive.
Yeah.
Intention is disclosed by its scope and wording. It still be regarded, and it may be that though the statute creates the duty and provides its penalty, the duty is nevertheless owed to individuals. Instances are Groves and Britannic. The duty may be of such paramount importance that it's owed to all the public. Now, in effect, that was the duty in Monk, but it's, if we're going to say road users, but anyone walking along a road is owed the Monk duty. Now, the point about that is that dictum was expressly disapproved. It's also referred to by Lord Justice Maugham at page 85, and it was expressly disapproved in this court.
But the important bit in Lord Justice Maugham at page 85 is the bit towards the end of the main paragraph, isn't it, where he says, second consideration which strongly tends to support the view that the statute was not intended to preclude a civil action is that it's brought by a person pointed out on a fair construction of the Act as being one whom the legislature desired to protect. And it's that which brought it within the Groves and Lord Wimborne territory.
Yes, but
that's the real underlying reason why in Monk and Warby said there's no intention to exclude. We don't deem there to have been a silent intention to exclude when this is the very person who's intended to be protected.
And the problem with that is, and that's why I said earlier that the same problem is found with Lord Justice Maugham as it is with Lord Justice Greer. It's looking at matters the wrong way round. The question is not, does the Act exclude civil liability? The question is whether or not there's a parliamentary intention to impose it.
Was Lord Symonds wrong in Campbell and Wandsworth about Monk and Warby?
Does your Lordship have a particular passage in mind?
Yeah, sure. Campbell and Wandsworth, Lord Symonds, it's tab 10, and page 407 and 408, and in the middle, the guts of it's in the middle of 408, but to set it in context, he started by Chief Justice Tenterton in Durham Bridges, just below halfway on 407, that the general rule, where Parliament creates an obligation and enforces in a specified manner, that's the only way. Then he says, however, that difference where you've got a protection of a particular class of person, and he cites Black and Fife Cole, Lord Kinnear, we've looked at, and then middle of page 408, after citing Lord Kinnear, an earlier and a later example will be found in Groves and Wimborne and Monk and Warby, in the former case of a public act passed in favour of workers in factories and workshops to compel their employers to do certain things for their protection and benefit. So he's citing Monk and Warby as illustrative of the point that you will readily conclude that Parliament did not intend the specified remedy to be exclusive where it is there for protection of a particular person. That seems to me to the very point which Lord Justice Morn was making, and you were saying is not now a good approach. It seemed to me that that was the very point that Lord Justice Morn was making, which is, as it were, echoed and endorsed by Lord Simmons.
But what Lord Simmons goes on to say is, but my lords, beyond the single fact that the performance by the respondents of their statutory duty will redound to the advantage of certain bookmakers, of whom the appellant may be one, I see neither in this Act nor in its attendant circumstances any element which takes this case out of the general rule, which I've taken from Lord Tenton's judgment in Doe, and that is, where there is enforcement by way of criminal penalty, that is the default.
Because they didn't treat this Act as intended to be protective of bookmakers.
And so we all come...
That's the point.
But I thought the one thing that everybody did agree was that Section 5 is intended to be protective of the workman.
This is the point that Lord Reid and I exchanged on earlier. The question is not, did the Act intend to benefit a particular class? It's whether the Act intended to afford them the right to sue in civil law.
Well, that's the circle we're running round, and I've been asking you how you clean it. If the old how you actually answer the question, and well, we're at the break, but I'm no nearer to a solution than I was.
That is a very suitable point, upon which we should, after a morning's listening to the arguments, rise to have a bit of a break from the argument, and we'll look forward to hearing from you further at 2 o'clock.